Hi, this video is going to start as a live video on Facebook, but I'm going to ask you all a personal favor. I'm going to ask you to watch a little bit of this video, and I'm going to ask you to share it. If you're a reporter, I'm going to ask you to contact me. But I want you to give me just 5 minutes of your time. This video is going to be longer than that, but there's so much information, but just give me 5 minutes. My name's Steve Vanderbol. I am a stroke survivor actually I'm a stroke victim due to the things I'm going to talk to you about. And I'm currently battling cancer. And stress is known to make cancer grow faster. It's proven, not a guess, it's proven. And the title of this video is dramatic, but it is also truthful. I, for the last 2 days, have spent, actually 3 days, spent them in bed trying to recover from stress and how my body's handling chemicals for fighting cancer. But I've had it. I've had enough. I've been fighting in the system, and now I'm going to state this in the public. I'm also a honorably discharged United States Marine veteran. I'm a Cold War veteran. I've never claimed to be Rambo. I have never claimed to be anything other than an idealist, a veteran, a lover of the Constitution. And this is where I'm going to start with this. The issue I'm going to talk about revolves family court, and everybody's going to roll their eyes. I don't care if you roll your eyes at this point in time. I would have also if I'd not found myself in this situation. But I'm a speaker of truth. And I've only told the truth. And I will only tell the truth. See, I'm not a hypocrite. I don't think too many out there can truthfully say that I'm about themselves. But I believe in this republic, and I believe in the rule of law. And Article 4, Section 1 of the United States Constitution is the full faith and credit clause. And the full faith and credit clause states very simply that every state must abide by the rules, legislative acts, or must recognize the legislative acts, public records, and judicial decisions of another state. In other words, if one state says something is law and a citizen of that state moves to another state, the new state must abide by the rules of the old state. This is important. Now, there is a federal law, actually it's a federal statute that the states have all agreed to, or most states have agreed to, called the Uniform Child Custody Jurisdiction and Enforcement Act, also known as the UCCJEA. Now, what this law assures is that child custody determinations shall be abided by. In other words, all states shall agree that they are sacrosanct. Meaning it's just not about child support. It's about seeing a person's child. It's about being involved in a child's life. It's about being allowed to parent. This law is abused non-stop in court. It was abused against me. Has been abused against me for 7 years, graphically, and I fought it for 7 years, spending hundreds of thousands, if not millions of dollars of my own money to win, and then to lose, and then to win, and then to lose. And how can you win and lose? Well, you can win things like mandates from the Oklahoma Supreme Court and the Judicial Court of Appeals, or the Civil Court of Appeals, that agree with your position, and then have a district judge later ignore them illegally and fraudulently under color of law. That's happened to me. The law is very simple. The UCCJEA states that if a court does not have jurisdiction at the first hearing, then it can never have jurisdiction, and all it can do is enforce the orders of the foreign court. In my case, the foreign court was the state of Missouri. I was married in Missouri to my first ex. We had a child. I was married for 14 months. It took 37 months to get a divorce. Why? Because of the unethical practices of the family court judges and attorneys. Now, I made an allegation, and I will support it. Now, we reached an agreement. We reached an agreement in 2006, July. By August, my ex-wife had broken that agreement, and I fought to get it to be enforced. But she was able to, living in the state of Oklahoma, stay outside the jurisdictional reach of the state of Missouri, and Missouri would not contact Oklahoma to enforce the order. Then, in 2011, a company I worked for raised $100 million, and I was the CEO of the company, and we issued a press release. The next day, illegally, her attorney, Kathy Christensen, and Sarah Schumacher filed an illegal lawsuit in the state of Oklahoma. Illegal. And it's illegal. It's a crime in the state of Oklahoma to file a lawsuit when you know you have no grounds to. And UCCJE is very, very specific. It states that the record of the first state, or the order of the first state, shall bear precedence over the orders of the second state. And in the original order in Missouri, it stated Missouri would hold jurisdiction until both parents left the state of Missouri or until the child got old enough, was emancipated, reached the age of maturity. I still lived in the state of Missouri. They knew so. Every piece of evidence they put in front of Judge Hammond, Judge Lisa K. Hammond, stated so. The UCCJ also states that I had the right to write a letter or to announce to the court that I was disputing it because another state had jurisdiction. And that court could not use that in any determination to determine that I was granting that state jurisdiction. 6 months later, Judge Lisa K. Hammond did that unlawfully. Now, there are two problems here. When they registered the Missouri order, the full faith and credit clause of the United States Constitution came into play. They ignored it. The Missouri order stated very clearly that when two parties try to have an issue, they need to mediate first. And there was no mediation scheduled. Now, Judge Hammond gave my ex-wife everything she wanted. She modified the decree. She removed my child. She removed my rights as a parent. She diminished my ability to see my child, and she increased my child support. All of it unlawfully. I was forced to go to the state of Oklahoma because the judge in Missouri, when I filed a motion in objection, said, we're just going to go ahead and give it to her because she just ruled on it, which was unlawful. You notice I'm not naming that judge's name because he erred in making a poor judicial decision. But under Missouri law, I could not appeal that decision. So I was forced to go to Oklahoma, where I was immediately jailed and immediately sanctioned and made to pay over $50,000 unlawfully. Now, from that point forward, in 2013, until June of 2015, there were 67 different filings against me in the state of Oklahoma by my ex-wife's attorneys, Kathy Christensen and Sarah Schumacher. By any means, that is called vexatious litigation. It's abusive process. It's unethical and it's illegal. Kathy Christensen also happens to sit on the Board of Judicial Complaints for the state of Oklahoma. Keep that in mind as the story goes on. I filed an appeal in 2013 stating that they didn't have subject matter jurisdiction. But I was ordered by Judge Lisa K. Hammond to file a motion to protect my child because my child was cutting himself. My child was physically harming himself. He carved, "No one cares about me," into his leg. What would you do if your child did that? Stand by and do nothing? Lose your mind and go violent? Or try to file a motion to ask for help? That's what I did. Did Judge Hammond do anything about that? No, she did not. She appointed an attorney, a guardian ad litem, Stephen Holden, who then listened to my son and said, well, his mother's really not abusing him. I've seen the children do this before just to get help so they can go live with the other parent. How many times have you seen children carve words into themselves? Yeah. Let's think about that for a minute. So, every 21 days, I was forced to appear in court in Oklahoma County while trying to run a multinational corporation, a multinational, multi-billion-dollar corporation. The stress was so egregious that I was literally coming to the United States for a court hearing for a week, flying overseas to do business, to come back to appear at another hearing, to be threatened to go to jail, and forced to write another check. Those checks went to the court clerk's office and were dispersed to Kathy Christensen and Sarah Schumacher and to court fees. In August of 2014, due to the stress, I had a stroke. My stroke went undiagnosed for 24 hours. I had half my lower brain removed. I was told I was not going to live. Everybody was told I was not going to live. This started two sections of events that grenaded in my life, and it eventually ended the corporation I was working very diligently to build, and people working very diligently to take parts of as parasites to the family court system. Because I didn't die, people who were embezzling monies from my company, that's another issue for another day. But I was forced to, in December of 14, on my birthday, barely 2.5 months after my stroke, without any support, was forced to go in front of Lisa K. Hammond again, where she browbeat me for 45 minutes for failing to turn over a shareholders list for a corporation in a family court issue, stating that she was concerned that I was hiding assets from my ex-wife. Now, Judge Hammond was trying to re-argue a divorce case that had been settled more than 5 years earlier, which was unlawful. I refused to do so because as a corporate officer, that would have been a felony crime, subject to 25 years in jail, and it would have been unethical and against the terms of my contract. So I did not do so. I was forced to pay my ex-wife's attorneys $15,000 within 3 days or go to jail for 6 months. Now keep in mind, my doctors did not want me to even sit in a car for an hour. Can you imagine going to jail for 6 months when you're barely able to walk? When you're being told that you can die at any moment due to stress, that you should not let your diastolic blood pressure reach more than 90 points diastolic, or you would have instantaneous brain hemorrhage. That's where I was, my birthday, in 2014. In February of 2015, the Oklahoma Court of Appeals came out with a ruling in my favor, citing that I was completely correct and the Oklahoma court had no jurisdiction to do anything. But there's an anomaly in Oklahoma law. The Civil Court of Appeals can't issue an order. It has to go to the Supreme Court, and the Supreme Court issues an order. So what Kathy Christensen and Sarah Schumacher and Stephen Holden did is they jointly filed motions between February and June. They were in June. Guess how many? 11. Trying to influence a new judge who was just appointed to the case, as Judge Hammond was so gracious to leave the case instead of recusing herself because she would have been removed from the bench, she asked another judge to be put in place and then mentored him. That judge was Richard Ogden. Richard Ogden is a thief. Richard Ogden is a felon. Richard Ogden is a crook. Richard Ogden is a bastard. And here's why I'm going to say this. The United States Constitution says full faith and credit. The whole premise of the legal system in the United States is a superior court tells an inferior court what to do, and they say, yes, sir, salute, and move on. This mandate said upon motion filed by this individual, case number FD 2011-14-18 would be dismissed. And every order subsequent therefrom, in other words, from the first hearing, every order from that would be vacated. Richard Ogden, prior to this order coming out from the Supreme Court, but it was known to the court, decided that he had jurisdiction based upon some action that had already been invalidated by the Court of Appeals and the Supreme Court. And he used this for some psychological head trip that he could sit there on his puppet dictatorship and espouse law, because he sees himself as a legal scholar. He's not. He's an idiot. Now, what I did representing myself pro se, because I fired all my attorneys when I saw the scam coming down, is I filed that motion. And then when they tried to jam it to me with court sanctions again, I took my son with me to court. And I forced my son to go, well, didn't force, I asked him. I forced my son upon the court, and my son sat down and testified in chambers with Stephen Holden and Judge Richard Ogden. I was not allowed to sit in. Judge Ogden didn't want a court reporter, but I demanded it and paid for it. A court reporter recorded my son's testimony as that my son was being abused by his mother and neglected, and that Mr. Holden was not listening to him and not bringing what he wanted to do in front of the court. Judge Richard Ogden reluctantly allowed me to take my son to the state of Texas under a temporary order, which wasn't valid because he had no grounds under this order to issue any orders. But under the Missouri order, I had the grounds as a parent to protect my child anywhere I wanted to take him. So I took him to Texas. Now, with that said, Judge Ogden immediately after that suppressed the evidence and denied me a copy of those transcripts. That is a violation of federal law. That prevented me from taking those transcripts to a Texas court and showing the child's testimony to a Texas judge to protect him from child abuse and neglect. Now, a year later, this comes up into play. Now in the middle, I'd gotten married a second time. And during my stroke, my second wife abandoned me in the hospital, left me for dead. Now when you wake up and find out that your wife isn't there, and your first memory of her is being mad that you're alive, that doesn't make it so amorous for you to continue a relationship. So our relationship broke down over several months. And in February of 15, the same month the Supreme Court mandate came, the Civil Order of Kills in Oklahoma came out, I asked her to leave. We reached an agreement. I had a son with this woman. She received $4.8 million in stock. She received a car. She received all the furnishings in the house that she wanted to take. She walked into a marriage with nothing and walked out very wealthy. All this under agreement based upon two things. One, that I would keep my youngest son with me until I died. And two, we would co-parent. And we would not file motions against each other. Because I did not want to relive what happened in Oklahoma. A month later, she breaks into my house, as reported by my caregiver, who wrote an affidavit, which is right here. Wrote an affidavit stating that she broke into the house several times. But on this occasion, she broke into a house and was sending text messages. Now, a year later, I get an emergency order from Oklahoma, Judge Richard Ogden, asking for a writ of assistance to remove my oldest son from the state of Texas, who's been in Texas for 9 months now, after I had filed a motion for Texas to assume jurisdiction lawfully under the UCCJEA. My second wife accused me when I was unable to sit, barely able to stand, of sleeping with 8 prostitutes at one time in front of my children in my living room. To completion. 8 hookers, 1 guy, 8 ejaculations. Post-stroke. I don't know whether to be offended or complimented, to be honest with you. Whatever man would not want to be known as being such a powerful and virile person to be able to do that? But what kind of retard believes that story? Seriously, what kind of retard believes that story? Evidently, the retards in Oklahoma, Richard Ogden, Stephen Holden, Kathy Christensen, Sherry Schumacher, and the First Ex. And they file this. Well, this is where the fun begins, folks. Because that's where they committed a federal felony. Because they went down and Richard Ogden picked up the phone and called a Texas judge, Judge Janelle Haverkamp in Cook County, Texas. Well, Judge Haverkamp already had the Missouri order registered in the state of Texas and also had the Oklahoma Supreme Court mandate recorded in the state of Texas. Under the United States Constitution, he had granted full faith and credit to both those orders. She failed to do so. Under Texas's version of the UCCJEA, she had to have a hearing prior to anything, and at that hearing, because of the registration of the Missouri order, she could only comply with the Missouri order and the mandates of the Oklahoma Supreme Court. But Judge Janelle Haverkamp decided, acting as God upon God to be on all people, decided to turn around and sign an unlawful writ of assistance. My first child was taken from me with the SWAT team, after my second child was taken from me by police. In a hearing on March 28th of 2016, Judge Haverkamp held a hearing. Here's the Oklahoma writ of assistance signed by Richard Ogden, dated 2016. The mandate telling him he doesn't have jurisdiction is 2015. This is evidence of a federal felony kidnapping crime. This is Judge Haverkamp. Actually, this is a Texas deputy's signature executing it because Judge Haverkamp told him to. That's facilitation of a federal felony crime. 4 of them. Suppression of evidence of child abuse and neglect is a federal felony. Kidnapping is a federal felony. Now, in the hearings on that day, Judge Haverkamp held one hearing regarding my oldest son, and she stated, we weren't having an Article 2 hearing, and I've already decided by prejudicial review. I filed an appeal of that with the Texas Appellate Court. Judge Haverkamp had her court clerk file a document with Court of Appeals asking the court clerk, this is just recently, 30 days ago, filing a court clerk asking them to kick it because they don't have jurisdiction because Judge Haverkamp never signed a final order. Judicial Code states a judge must file a final order on the bench. She failed to do so. Now, I just filed a response a few weeks ago stating very simply that as Judge Haverkamp signed the writ of appeal, or the writ of assistance, and as the court records and transcripts showed that she denied having a hearing, that was a final order and there was grounds for jurisdiction in the appellate court. Strike one against Judge Haverkamp. Let's see what the Court of Appeals says. Now, there's been a year in that because I have filed 7 motions with 3 different judges trying to get Judge Haverkamp's temporary orders overturned because they were unlawful. Now let's move on to the second case that Judge Haverkamp heard that day regarding my youngest son. Judge Haverkamp, then in statement, came in so biased that she threw the courthouse at me. And in a second hearing was actually asking me questions about the Oklahoma case and how I was refusing to abide by orders of the Oklahoma court. And every time I try to answer a question, she would tell me to shut up or something worse. No respect, no decorum, no judicial conduct. Clearly biased. So we walked out of the courtroom and I asked my attorney to file a motion for recusal. It took 6 months to file that motion because the transcripts of that hearing didn't come out for 6 months, so I could not appeal or ask for a writ of review. Why? Because Judge Haverkamp ordered her transcriptionist not to release the transcripts. A felony offense. Well, finally, when we got the transcripts out, July 8th of 2016, Judge Haverkamp issued this letter. Now, the Texas Rules of Judicial Conduct states that a judge cannot testify as to why they were recused. They can just recuse. Okay, I'll step out of the case and you can find another judge. Judge Haverkamp didn't do that. What she said, despite her own testimony where she did her own review in transcripts, in hearing, and despite the fact that she said that she had multiple conversations with Judge Richard Ogden, this is what she said. In response to respondent's motion to recuse, the court did not do her own research. Sorry, Judge, you say it 11 times in the transcripts. Judge Ogden from Oklahoma County called this court to inform the court that the identical child custody matter respondent filed in Cook County had commenced, was already actively litigated in his Oklahoma court. She had the mandate in front of her that said he didn't have jurisdiction and it was adjudicated. It was done. And Supreme Court had told her to ignore Ogden. Per the Family Code, this court was required to communicate with the Oklahoma court to resolve the issues. The Family Code in Texas is Title 5, and it's Section 156, Title 5, 156, and in 156 point, I think it's 408, yeah, 106, 408, it states that a judge must have a hearing prior to making a determination and must hear all sides of the fact and must support a foreign order of a foreign court, the Missouri order and the Oklahoma Supreme Court. Now here she says, after conferring with Judge Ogden, this court determined Oklahoma had jurisdiction. No, Judge Haverkamp, a minister to the court outside of the law, decided to say, the law, and I'm going to do what I want to do. Then she goes, although I do not agree with the respondent's motion to recuse because the respondent has now questioned my impartiality, I voluntarily recuse myself. Judge Haverkamp, you're biased. Everybody in the frickin' county knows it. There has been 5 movements to get you removed from the bench in Cook County. prior to me filing a motion or filing letters with the Texas Committee for Judicial Complaints. Welcome to the face of your demise. I'm saying it, and I'm seeing two people from Cook County on here listening to it. I'm pissed. I've had it. Now, Judge Richard Ogden then turns around and writes this really cutesy thing after Judge Haverkamp gets recused. Judge Woodlock comes in for him. And then Judge Ogden, who has now taken my oldest son federally in violation of federal law, kidnapped him to another state, changed orders that he cannot change, orders me to pay my ex-wife $9,000 a month and over $100,000 in legal fees to people who are not allowed a flippin' dime. Comes back and says, on Friday, October 7, 2016, this court, Judge Richard Ogden, confirmed with the Honorable Senior District Judge Jerry Woodlock for the District County of Cook County, Texas. Judge Woodlock is assigned the matter involving the same parties, the same state and child of Texas. Prior to this conference, this court, the Honorable Janelle Haverkamp, the judge previously assigned in Texas, had conferred also that Lisa Hammond, the judge previously assigned to this matter in Oklahoma County, and Judge Haverkamp conferred with the prior Texas case of all the same parties in minor case number CV 272. In other words, Judge Ogden, in his admission, admits that the Texas judges ignored Texas law and repeatedly conferred without hearings with the Oklahoma court and violated my federally protected rights. It's right flipping here. And signed. This is an ongoing conspiracy in the family court system to conduct an illegal enterprise. This is a subpoena to compel the evidence from Judge Richard Ogden regarding my son cutting himself and his testimony that his mother was abusing him. And he says, since it doesn't comply with Oklahoma law, I don't have to honor it, and I'm not going to give it up because I don't have to, because I'm a judge and you're not. No, you're a citizen. Because when the Oklahoma Supreme Court said you didn't have jurisdiction, you don't have protection under the law. Now this is where it gets really interesting, people, because I filed a federal case. I filed a federal case in the Western District of Oklahoma in front of Judge Joe Heaton. Federal Judge Joe Heaton. The first federal judge recused herself because she knew Kathy Christensen. Judge Heaton knows Kathy Christensen. I've got photos of them hanging out together. I've got them photos of them attending a governor's ball together. You hearing this? I have evidence of collusion. But I filed a very complicated motion, and the judge dismissed it the first time because it didn't meet the rules of federal civil procedure, which was crap. So I filed it again, and this time I stacked a lot of questions in it, because with a federal case, you can ask federal constitutional questions. So I asked a lot of them, like, how could Oklahoma violate the full faith and credit clause of the U.S. Constitution, the Missouri issue? How could Oklahoma, the Oklahoma court, after it was told it didn't have jurisdiction to redetermine it had jurisdiction in violation of the Oklahoma Supreme Court mandate? How could the UCCJEA be ignored when the UCCJEA states that jurisdiction starts at commencement, the first date, 2011, and then anything determined, if you don't have jurisdiction then, nothing is valid. Now, in that complaint, I asked for $240 million in damages, which I can support. Every frickin' penny I can support. Now, Judge Joe Heaton, who knew Stephen Holden, Sarah Schumacher, Kathy Christensen, Richard Ogden, and Lisa Hammond, because Heaton taught classes at Oklahoma Law with these people, knew them. So Judge Heaton very arrogantly, after 6 months of deliberation, refused to force them to answer my complaint, which is beyond usual, because they filed motions to dismiss for failure to make a claim which the court could grant relief, which is bullshit, because I was asking constitutional questions. The court had a duty to answer the constitutional questions. Well, Judge Heaton said, Mr. Vanderbol somehow does not realize that Oklahoma somehow determined that it had jurisdiction. Well, jackass, that's what I was asking you to tell me, how it was fucking constitutional. You're a fucking federal court judge. You're supposed to tell me, the stupid citizen that I am, how this is constitutional. But you didn't do it. And you wrote your order, and everybody on your side went, yay! Because we can continue to fuck Mr. Vanderbol. No, not really. So an appeal came down. Actually, it came down where I could file an appeal. And I filed appeal with the 10th Circuit Court. Actually, with the 5th. Actually, I filed it with the 10th, and it got assigned to the 5th. And the 5th assigned it back to the 10th. In my 88-page complaint, there are 14 constitutional questions that Judge Heaton ignored. In his one answer, he stated that Judge Ogden and Judge Judge Hammond had judicial protection. Evidently, Judge Heaton was too stupid, arrogant, or blind to read one line. And I apologize because I didn't highlight this because it didn't come to the point that I was going to talk about this until this point. The record shows the trial court did not have subject matter jurisdiction. The trial court, this is the Oklahoma court, this is Lisa K. Hammond and Richard Ogden, did not have subject matter jurisdiction to modify Missouri's custody determination at the time of the default order of modification. That's 2011. In case with similar facts, the Oklahoma Civil Court of Appeals has previously held that judgment modifying another state's custody order without subject matter jurisdiction is, under the CCJEA, is void. A void judgment or decree may be vacated at any time or motion of party by a person affected by it, thereby me, that's me. Because the custody modification order is void, the trial court abused its discretion in denying the father's request to vacate it. Abused its discretion. Further, in this order, it stated, remember, she didn't have jurisdiction and abused their discretion. There's another portion in this order that states very clearly, excessive authority. Now the question I asked, and I asked it very directly, was if Judge Hammond erred in abusing her discretion, and then Judge Ogden replaced her, Judge Hammond may be legally protected under the law as being immune from prosecution. But what about Dickie Ogden? Because everything he did after this order came out, including kidnapping my kid, including coercion with 2 other judges to violate my parental rights with my 2 children, including taking hundreds of thousands of dollars of my money and seizing my bank accounts unlawfully That's called color of law. That's what I asked the federal court for protection from. That's what I sued for under federal law. Now, why am I so fired up today? Missouri, Oklahoma, Texas. Second ex-wife's attorney, Bijou Pillai. Bijou Pillai. A legal aid attorney. A legal aid attorney is supposed to help their people who don't have any money. And it's supposed to sort of ethically to do only ethical things, has been representing my second wife. You remember the one that broke into my house and made up a story that I was sleeping with 8 hookers? That shining piece of work. Well, back in June, I had a hearing in front of third judge, Lise Isaacs. Judge Isaacs. At this point in time, I'll reserve my opinion to her ethical behavior. And we asked for a break. I asked for a break. We went outside, and I asked him, representing myself pro se, I said one thing. I said, dude, I likely have cancer. I just want to see my kids before I die. What does your client want? Let's just end this. What does your client want? His response to me was this: I don't think we can get there. What does your client want? Was my question. I just want to see my kids. I don't think we can get there. This sack here is Texas state law stating where I have a right to see my children. I haven't seen my oldest in almost 2 years now. Haven't seen my youngest in 8 months. Now my buddy Zach, who's sitting here, and several other people witnessed what happened next. When I turned around, Bijou Pillai rolled his eyes and smirked. That's the kind of piece of shit that's in the family court system. So I already told him then I had cancer and I just wanted to settle this damn thing. It's not in his best interest to do it. He just wants more money. So we walked back inside, and it was a hearing to dismiss all this temporary stuff from Judge Haverkamp we talked about. The one where all these allegations I'm humping hookers and doing all these things where I can barely stand and walk and I'm fighting for my own survival. Taking care of 2 kids that are mine biologically, and my second one dumps hers from a previous relationship on me. So I really have 3 sons. I was father to the one in the middle from the time he was 5.5 months old. And I bought him everything he ever had in his life. And I love him. I do. Miss him terribly. Can't do a damn thing about it. He's not mine, and I don't have a legal right to him, so I largely have to live with the fact that I will never see that child ever again. But the other 2, biologically, are mine, and I have rights, and I'm fighting for them. So Bijou sends me an email this morning. And Bijou I like to refer him as BJ, sends me an email this morning. Now keep in mind, he sent me a long list of stuff that he wanted a discovery, half of which he's not entitled to. And it's not really, doesn't make any sense because we already have a settlement agreement that's in place that he's trying to break, unlawfully, by the way, that was signed after my ex filed the stuff that she filed in violation of our first agreement. Texas law says the MSA has to be put in place, and both parties have to go suck it. That's what Texas law says, basically. But he says, if you recall, I resubmitted the discovery request to you on June 28th. See my prior email, which came with the new 30-day deadline. fuck your 30-day deadline. And as of today, I have not received your responses. Will you go ahead? I will go ahead and give you another 7 days to respond. Please have your response by the end of the business day on Wednesday. Now, my buddy Zach didn't tell me that he rolled his eyes. And I'm really thankful. Because after 8 years of dealing with actually, I'll go all the way back to 2003. 14 years of dealing with bullshit in the family court system. Watching my mother and my grandmother die of cancer, not seeing my grandmother not seeing her oldest great-grandchild. Actually, her only great-grandchild at that time. And my mother not being able to see her oldest grandson before she did die because my ex-wife was jacking around with custody. And after having to pay for supervised visitation because Judge Haverkamp illegally threw the book at me and called me a violent threat because simply I told Judge Ogden that he didn't have the lawful jurisdiction to rule anything because the Oklahoma Supreme Court said he didn't, that neither Judge Haverkamp or Judge Ogden liked. They didn't like it. Tough shit, it's law. I didn't call him a name. I said, as I stated to you prior to your submission of this attached email, I have cancer. I have something more important to deal with than your request and constant torments over something that is frankly final. He likes to send me hate mail every Friday to stress me out over the weekend. Does it every freaking week. Kathy Christensen and Cher Schumacher did it for 8 years. It's what led to my stroke. And I'm not dealing with it anymore. I'm not playing with the games anymore. That's why I'm on the record here. This is the crap that goes on. It's illegal. It's unethical. It's immoral. Needs to stop. Let me digress. I have something more important to deal with than your requests and constant torments over something that is frankly final. It is your illusion and drive to propagate discord that continues the pain I have in my life. I'm in the process of engaging an attorney. As you have no human decency or respect for anything other than your income stream, you can deal with him directly. I am moving for review of Judge Haverkamp's biased and incorrect determinations. I've only been doing so. This document here, actually, yeah, this document here is called a memorandum of law. It's 46 pages long. It had 117 separate exhibits to it. They went in front of 2 other judges. And both the judges said very curtly, I'm not the appellate court. I can't do anything about it, when the rules of judicial conduct says they can. And the rules tell them if they see something grossly unjust, they're supposed to stop it. But remember, Judge Haverkamp didn't sign a final order, and then she tries to get her clerk to say, I didn't sign a final order, so you don't have jurisdiction. That's the game they play. Which is why I'm on this camera right now. Personally, Mr. Pillai, you disgust me. You know your case has no legs or merit. Your client is an addictive due to collusion with my first ex. You are the primest example of what I will strive to end in the family court system, the opportunist parasite. Yes, I called you a parasite. Deal with the truth. In short, do not contact me again with any of your cutesy comments or deadlines. Directly, if you've done nothing to end this conflict and everything to promote it. I view you as filth and the reason my son suffers in daycare for hours each day instead of the care of someone who loves him. I hope you are proud of the shame that you bring to your family name. Now, with that said, wait for contact from my attorney. Hugs and kisses, Steve Vanderbol. Now, I apologize for my behavior in this video, but I'm fed up. This is so stupid. This is so absolutely stupid that we live in a society that allows people to create a collusive criminal enterprise for profit and damages the very fabric of our society, the family. I've had 5 psychiatric evaluations during this process. At each time I've been called the same thing or been said the same thing. Overly capable, highly intelligent, committed to his children, dedicated to the family, ethical, moral, capable of compromise, lawfully abiding, no known or foreseen defects, and here's the fun one. Here's the funnest one of all. A model parent. Because each one of those psychiatric evaluations come with a parenting analysis. 5 times. Each time, $5,000 minimum. $25,000 for Judge Isaacs to want me to do it one more time. No. I'm not going to abide by any more of these bullshit temporary illegal orders. See, what I learned in Oklahoma for the 5 years that I had to play that game there is every time I went in and wrote a check, every time I tried to play by the rules, every time I tried to be a good boy in their eyes, I just was a sucker. Because when that Oklahoma Supreme Court mandate came out, Kathy Christensen, Sarah Schumacher, Stephen Holden, and the other parasites up there were responsible to me for the debt they owed me for all the fees and everything else that they collected illegally. When they doubled down and took my son back to the state of Oklahoma, they committed felony crimes. 25 years in jail. I don't want my money back. I want each one of them in jail. Now, I've said this story. I've bared my soul. I've shown I'm not perfect. I'm human. This is real. This is my life. I ask you to share this video. I ask you to promote it to reporters. I ask you to take it to law enforcement. I ask you to take it to the FBI. I've been to the FBI. I've been to the Oklahoma Attorney General's office. I've been to the Texas Attorney General's office. I've been to the Federal Bureau of Investigation in Dallas. I've sent to the Federal Bureau of Investigation in Oklahoma. I've been to the state house in Oklahoma when I had 5 warrants for my arrest. We can't do anything. It's above our pay grade. That just cost me my pension. It violates the law. Sorry, dude, can't do anything about it. The last FBI agent I talked to was sitting there, and behind him, he had an Eagle Globe and anchor on the wall. A fellow Marine. Any of you really know me, know exactly what it took for me not to say exactly what I was thinking. I won't give them the reason to arrest me. I need help. And it's not the judiciary. It's with you. Thank you for watching. If you have any questions, any comments, my website's roguefather.com. You're seeing this on Facebook. You can post me here. My email address is rogue@roguefather.com. I'm open for any interview, law enforcement or press. And I'll provide all the documentation, every single sheet of paper. But I've just laid in front of you how 4 judges colluded with each other to propagate a criminal enterprise in violation of state and federal law. It's on the record now. I have the federal criminal statutes to back up. Right here in this memorandum of law. God bless you all. Have a good day.